And before we address the claim on the merits, I think perhaps this good time credit issue needs to be addressed.
Yes, sir. Yes, sir. Can you see it, Crawford?
A habeas corpus petition, a disputed disciplinary report, and a possible loss of earned good time credit. This hearing just got serious. Mr. Cheatham claims due process violations, while the department says only 15 days segregation was imposed. But if good time was lost, everything changes. Subscribe for more dramatic breakdowns.
The Kansas Department of Corrections. This matter is before the court today for hearing on a petition seeking habeas corpus relief under 60-1501. This is also a venue transfer from Pawnee County. Mr. Andrews, do you have any initial statements that you wish to address the court with?
Yes, Your Honor. I would be requesting a continuance to a later setting. I had the opportunity to speak with my client for the first time during this hearing, during a breakout room before we started this hearing. I've reviewed Ms. Fowler's motion to dismiss, which essentially argues that there was no due process rights because there wasn't a loss of a liberty interest or a property interest. But my client has indicated that he did lose earned good time credit as a result of this DR proceeding. And earned good time credit does create a due process right as opposed to potential good time credit loss, which does not. I am wanting to follow up to see if I can get some proof on the specific number of good time credits that were lost as a result of this. And that way we could present that to the court as proof that there was a due process right involved, and then request further proceedings based on that.
All right, Ms. Fowler, I think you represented in your answer that the penalty imposed was 15 days of disciplinary segregation. Is that correct?
That's correct, Your Honor.
Okay. Where did you get your information regarding the sentence that was imposed?
Your Honor is speaking to me.
Yes.
Yes, thank you. From the disciplinary report, that's where I received that information. That is where the disposition is kept. I'm not sure.
Which should be part of the file, but.
Yeah, and it should be attached as an exhibit, the disposition, which indicates what his sentence was. I'm not sure where he has received information that he lost good time that was earned at that point.
Okay. I see the appeal to the secretary's decision. But it doesn't mention the sentence. And I know that the Pawnee County Court did ask for supplementation of the record to make sure that they had information such as this.
And Your Honor, if I could, I'm looking at what is Exhibit G, and that's the Secretary's decision, and it just approves the disciplinary report and disposition, which was that 15 days.
Okay.
And Your Honor, what was conveyed to me by my client is that as a consequence, anytime an inmate is found guilty of a violation of a Class 1 violation, that it results in a loss of earned good time credit that had been earned for the preceding the period of time immediately preceding that. And so my understanding from what he was telling me is that it's not a separate sentence that's issued, but is a automatic consequence of any violation of a Class 1.
Okay, I want to back up a moment. Ms. Fowler, is the sentence that has been affirmed by the Secretary stated in Exhibit G, and if so, where?
It is not stated in Exhibit G, it just approves the decision.
Okay.
And it's just a checkbox.
May I address the court, Your Honor?
I'll allow that in just a moment, sir.
Okay, yes, sir.
I do look and see the supplement to a disposition of a disciplinary case. And sanction is clearly listed as 15 days D/S, which I'm going to interpret as disciplinary segregation.
That's correct, Your Honor.
And then C/S, and then it has a time frame 9/29 to 10/13, which would seem to suggest to this court that that is the 15-day period for the disciplinary segregation. So the court agrees that at least at first glance, it appears that the only sanction imposed was 15 days disciplinary segregation. But Mr. Andrews, you're arguing that somehow that there's some sort of loss of good time credit already earned, which is inherent in such an order?
That is what I was informed of, yes, Your Honor, by my client. And it sounded as though there was a official in the room with him, EDCF official with him. I didn't identify who that was, but it sounded to me as though that person was confirming that belief, although I didn't have the opportunity to really fully explore that.
Okay. Mr. Cheatham, you wanted to address the court directly. I'll give you the opportunity to do so now.
Okay, yes, sir. So there's this thing with this good time credit. My unit team is actually looking at it right now. I don't know if he could speak on or talk in this matter, but also my thing was that they wanted me to raise my right hand to be sworn in, and according to the DR book, that's not a part of the procedure. So there was never a record established, is what my argument was. So when the Secretary of Corrections remanded for clarification of a record, I don't know. I mean, maybe should I ask the courts their position on this? Shouldn't it have been another hearing, remanded for a new hearing? Because how can they clarify a record that was never established due to me not raising my right hand to be sworn in? And that was against my religious purposes. Like I tried to voice that. I just got removed from the hearing because I wouldn't raise my right hand. So that was one of the other issues I wanted to address to the courts. Like that's due process, isn't it? If it's not required by rule book to swear, raise your right hand to swear in.
Here's the legal turning point. If only 15 days of disciplinary segregation were imposed, there may be no protected liberty interest. But if earned good time credit was automatically forfeited, that triggers due process protections. The entire case hinges on proof. So, did he actually lose time or not?
Okay, I think we're getting ahead of ourselves here.
Okay, yes, sir. My bad. Sorry.
I think Ms. Fowler is arguing you may not even have the right to bring this claim.
Okay.
And before we address the claim on the merits, I think perhaps this good time credit issue needs to be addressed.
Yes, sir. Yes, sir. Can you see it, Crawford? My unit team's looking. My bad. Sorry.
Ms. Fowler, I'll give you the floor.
Well, Your Honor, I would like the opportunity to speak with, is it Mr. Crawford, who's back there? I'm not sure exactly what it is that we're talking about here, but if we're going to entertain that Mr. Cheatham potentially lost good time, then I would have no, objection to the continuance, but I'd like the opportunity to speak with Mr. Crawford if he's going to be a witness.
Okay, fair enough. It would appear that the continuance might allow both Ms. Fowler and Mr. Andrews access to additional information in this regard that obviously would be helpful to the court. Perhaps the continuance request should be granted, Ms. Fowler, and you can look into it further. I trust you did not anticipate this would be the claim that would be made today.
No, Your Honor.
Okay. In fairness, I tend to agree. Mr. Cheatham, we very well at some point may get to the concern that you raised this morning, but I think we have a threshold issue here did you actually suffer a loss of good time credit already earned or not?
Right.
It's not obvious from the records before the court that you did.
Okay.
But I'm going to give Ms. Fowler and your attorney the opportunity to look into it to see if that is indeed the case, because it does have some bearing as to whether this case will go forward. So we'll reschedule this matter. How much time do you think is necessary, Ms. Fowler, for this to be looked into further and perhaps information shared with Mr. Andrews?
Within the week, Your Honor.
Okay, I appreciate that. Unfortunately, time on my calendar in a week is unlikely to be found. On the other hand, I do have a light Greenwood and Elk docket. Those are my other two counties. And I might be able to work something in on Thursday, February 26th. It's a little more than the week you asked for. Are you available the afternoon of Thursday, February 26th, Mr. Andrews?
Your Honor,
And I also need to remember that EDCF, I think, has a request not to schedule late afternoon hearings, or at least after a certain point. So what was your response going to be, Mr. Andrews?
Your Honor, I would prefer not to. I do have that afternoon blocked, and frankly, I was really kind of hoping to have the opportunity myself to speak with Mr. Cheatham between now and the next hearing. And with my calendar, I don't think that would be realistically possible before next week.
All right. All right. I'm going to request from my assistant here, is March 12 available for scheduling, Mandy?
Yeah, that's
Okay.
Your Honor, I'm not available March 12. I'm going to be on my way to Florida that day for the and through the following week.
Okay.
I'll be out between March 12 and March 24th.
Mr. Andrews, Ms. Fowler, your availability on the afternoon of Monday, March 30.
I have a case management conference by Zoom from at 2:00. So I would be available from 1 to 2 or 3 to 5.
Okay, again, I think
you're
that flies in face of DOC policy regarding availability for Zoom.
1 to 2 would be fine, Your Honor.
Well, I've already got a case
Okay.
set at 1:15, unfortunately. I also could look at the morning of March 31.
Your Honor, I have a 9 o'clock hearing, but then I'm free the rest of that day, so I could do it from 10 o'clock on.
Okay, 10 o'clock then on Tuesday, March 31.
That works for me, Your Honor.
All right, thank you.
Thank you, Your Honor.
The Cheatham matter will be reset for further hearing by Zoom Tuesday, March 31, 10 o'clock a.m. Generally speaking, we're going to issue a new order for Zoom hearing and get that out to the facility. I do appreciate the facility's accommodation this morning. March 31, 10 o'clock for further proceedings in the Cheatham case. And at that time, the court will address as a threshold matter this good time credit issue, which has been raised here today. Ms. Fowler, anything further we need to address currently?
Nothing from the department. Thank you.
Mr. Andrews, anything further at this time?
No, Your Honor.
All right. We'll see you then March 31 at 10 o'clock, Mr. Cheatham.
Yes, sir. Sounds good. Appreciate y'all. Thank you.
All
See you soon, Mr. Andrews.
Thank you. Yes.
If there's nothing further, the Cheatham matter will currently be in recess. This meeting may be ended for all.
Instead of ruling, the judge zeroed in on the threshold issue, proof of lost good time credit. No confirmation, no case. At least for now, the hearing resets, tension unresolved, and everything depends on documentation. Will records confirm Cheatham's claim? Like, comment, and subscribe for more shocking courtroom stories.